Hi, classmates. This is Timothy Marks doing Chapter 18 on employment discrimination. Sorry, I couldn't link the video with the PowerPoint. However, I'm going to go through the PowerPoint slides, and you can do that at your leisure. So what I'm going to talk about is a recent New York Times article that was from June 19th, just a few days ago, about second chance for ex-offenders and the Federal Equal Employment Opportunity Commission. It was a June 19th article in the New York Times where they barred employers, which bars employers from automatically denying people based on arrest or convictions. Arrest alone was not a proof of illegal conduct or grounds for exclusion. Employers during this type of discrimination must take into account the seriousness of the offense, the time lapse since the offense, and the relevance of the crime to the specific job being sought. For example, if somebody has a lot of traffic crimes or traffic felonies, you wouldn't want them teaching driving school. So why is this law in place, or why is there protection? To eliminate unfair obstacles to employment for the 65 million Americans who have criminal records, including those based on minor convictions that might have occurred in the distant past. So, violations of the Title VII of the Civil Rights Act. The story talks about two different cases, one of them being at the Dollar General retail chain, where discriminatory background check policies had disparate impacts on minority applicants and employees. The Dollar General discriminated when they disqualified job applicants for a variety of crimes, including reckless driving and possession of drug paraphernalia, without considering the relevance of the offense to the job. 10% conditionally hired black employees were discharged for failing background checks between 2004 and 2007. So this is the long time in the making. However, only 10% of black employees were discharged, where 7% of all others were discharged for similar offenses. The other one is a kind of a confusing conglomerate from the automaker BMW, a factory out of South Carolina in 2008. A contractor hired by the automaker applied a company screening policy that had a disparate impact on the minorities and denied employment to anyone that worked in the plant for years without incident. The company dismissed 88 employees for having criminal records. And I'll talk a little bit more about that case in a minute, because these were long-time employees that were, when the new contract went into place, had to reapply for their own jobs. So the Title VII of the Civil Rights Act, enacted in 1964, this act and its amendments prohibit job discrimination against employees and applicants and union members on the basis of race, color, national origin, religion, or gender at any stage of employment. For this to be applicable to a company, they have to have at least 15 employees. The compliance is monitored by the Equal Employment Opportunity Commission, known as the EEOC, and wronged employees must file a complaint with the EEOC before bringing a lawsuit to court. The EEOC investigate the cases on a as-needed basis for the claims that are priority cases. They don't investigate every single case. So there's several types of discrimination. There's an intentional type of discrimination, or disparate treatment discrimination, where they must prove that the one that is being discriminated against is a member of a protected class. They were applied for and qualified for the job that was in question. They were rejected from the potential employer, and the employer continued to seek applicants for the position or filled the position with a member of a non-protected class. So this brings into one of our terms from our book, prima facie, or at first sight. and that is the fact that is presumed to be true unless contradicted by the evidence. So the burden of proving it to be untrue is on the employer. Unintentional discrimination or disparate impact discrimination is when a protected group of people is adversely affected by an employer's practices, procedures, or tests, even though they do not, on face value, appear to be discrimination or discriminatory. So in that case, the plaintiff must, or the complainant must, statistically prove that discrimination practices were in effect. The pool of there's two ways that can happen. The pool of applicants, which is comparing the employer's workforce with the pool of qualified individuals available in the local labor market, and the rate of hiring, which compares the selection rates of the employer versus a protected class, regardless of the racial balance of the workforce. The defendant in those cases must show that their practices or procedures in question were justified. And the EEOC uses a 4/5 rule or 80% rule. Other forms of discrimination are reverse discrimination, religious discrimination, gender discrimination, including the Equal Pay Act, pregnancy discrimination, disability discrimination, sexual harassment, same-gender harassment, and then on the other side of that is retaliation by employers. And a term that's important in knowing that fact is constructive discharge, where an employer causes an employee to resign from having such an intolerable working conditions that a reasonable person in the same position would feel compelled to quit. So remedies that are available for discriminated potential employees or employees: reinstatement back into the job, back pay from when they were let go, retroactive promotions if they missed any in the meantime, and monetary damages. The compensatory damages are only available in cases of intentional discrimination, and they range anywhere from $50,000 for small companies up to $300,000 for large companies. The EEOC and remedy in this case, I'll read the quote: "The Commission is committed to using public education," or actually this is the EEOC and all of its methods. The Commission is committed to using public education and informal resolution to address discriminatory hiring practices. When these methods are unsuccessful, the Commission will, if necessary, seek redress from the federal courts and ensure equal opportunity for all. This is the latest in a series of systemic cases the Commission has filed to challenge unlawful hiring practices, and that was the General Counsel of the EEOC, David Lopez. So attached in the references of this PowerPoint is the full enforcement guidelines. So the ethical implications that lie in here, inherent in this case, have to do with the more recent conversations regarding affirmative action, and recently in the news, as recent as the 25th of June, was the Texas affirmative action case, where the majority decision decided to send the case back to the lower courts by a 7-1 majority decision from the Supreme Court. They didn't specifically rule on the issue. The story in that case, which is kind of similar, but a different affirmative action, is a different case altogether, but has to do with hiring practices. This was having to do with getting accepted into school. The story is that a white female student was denied acceptance to the university. The university stated that they take the top 10% of all Texas graduates, and then after that they take account of academic achievement and other factors, including race and ethnicity, in their acceptance practices. The plaintiff, in this case, was below the 10%, so didn't get in off of grades alone, and didn't make the cut on the other criteria either. On first glance of this article, it seems that she was kind of bitter that she didn't get in because her grades weren't good enough to get into this local university. But upon further intro and retrospection, um, is affirmative action necessary in today's age? So the question, if the university selects the top 10% of all graduating seniors, regardless of race, color, or gender, um, then why need this specific guidelines for outside of the 10%? So the plaintiff argued that the diverse group was already in the top 10%, and further selection based on race and ethnicity was a further slight against her fair chances to get into the university. So, with that being said, it begs the bigger question of whether our society is ready and at the point where we no longer need these types of laws and protections. Uh, my personal view is not quite yet, but we're getting a lot better. And maybe in 10 years or so, we won't need these types of things in order to make sure the playing field is level for everyone. Again, so I wanted to talk about the Chapter 18 um, topics, which was employment discrimination. So I outlined some of those major topics and also the uh, the different types of discrimination inherent in employing individuals and in the workforce. Uh, this was a cursory review. There's a lot more information in depth, both in the text and in articles that you can find. But I thought that these two articles were both timely, relevant, and spoke to the major facts regarding to current day employment discrimination. Again, my name's Timothy Marks. This is Chapter 18, Employment Discrimination. Thanks for your time. Have a good day.